we're now talking a bit about records and including some of the HIPAA issues. Basically, I've talked about how important it is to document, and there's a distinction between, as all of you have, I think, are now familiar with, between what's considered a psychotherapy note and a medical record. Where does the information, for example, about threats of harm, about suicidal behavior, warnings, and so on, where does that go? Does that go in the medical record, which is a more generic set of information that might be disclosed, for example, in workers' comp cases and so on, or does that go in the psychotherapy note? My inclination would be, and there's no hard and fast rule that I've seen legally that says where it goes, but my inclination would be to assume that this goes in the psychotherapy note. This is about specific information that's disclosed in the therapy note. One could argue that it's about progress and symptoms, and therefore should also go in the medical record. But I think that one of the benefits that we have of keeping this kind of material in the psychotherapy note is there are heightened privacy protections. And so we're required to be more thoughtful about, can we disclose it, should we disclose it? In the example of a workers' comp case where they say, give us all of your medical records, we don't need your psychotherapy records, but we want your medical records, we then have the opportunity to think about, okay, what is in the psychotherapy record that might be relevant, and getting releases, or as it now is called, an authorization to do that. Or, okay, I've got all of the information that I need about progress, symptoms, and so on in the standard medical record. The details of the warnings that I've made, my evaluation of suicidality, and then a contact with the family. Perhaps the symptom is documented in a medical record, but I have all the details in the psychotherapy note, and I am not required to release that. Okay. So I tend to think of my general sense about the tension in records is it's a tension between trying to maintain privacy and trying to maintain good quality and continuity of care. And so do I really need to release the exact information about what I said to the live-in partner of a client of mine when I was trying to forestall the suicidality? Do I really need to include that in information that I send to the workers' compensation board? No, I don't. I want to keep that private. It may be very helpful for me to have that information so that if my behavior is challenged and my professional kind of decisions are challenged, I'll have a basis for saying, here's why I thought to do this, here's what I said, and then it can meet the reasonableness standard. Okay, so I use that kind of decision rule to help me figure out what goes in the, quote, medical record and what's going to be in the more private psychotherapy note. A psychotherapy note is defined under HIPAA rules as notes by the mental health professional, okay, about the contents of sessions. So it's notes about the contents of sessions. It can be about any kind of session, group, family, and so on. And one of the important dimensions here in defining a psychotherapy note is that it is separate from the medical record. Other folks in other places, they say it's inappropriate for the medical record. So it can include things like a psychotherapist's impressions about the patient, details of conversations, quotes. One of the things that I think many of us do is certainly, where there's something that a client says that really encapsulates a theme they've been struggling with, or a realization they've had, or defines a problem in a way that really helps us think about how we're going to intervene. We regularly might put that information in a quotation mark, under quotation marks in our record. That would be the kind of thing that would belong in a psychotherapy record. On the other hand, and admittedly, the law's distinction here leaves a lot to be desired, but what is not a psychotherapy note, what is considered a medical record, is the following. It's notes that we have about the times of the service, the date of the service, how often they happen, medications that are used, the type of service. For example, is this an individual session? Is it a group session? Test results, even including raw data. So that's not considered part of a psychotherapy note. Raw data of many of our traditionally very valued psychological tests, not as part of a psychotherapy note. And then a summary, this is again part of a medical record, a summary of diagnosis, the diagnosis, symptoms, treatment plans, progress, and prognosis and progress to date. So you'll notice that these are, basically what gets defined as a medical record is very, very thorough information, but the more specific content that's not a summary, that's the actual data underlying what's going on in a particular session, that's the psychotherapy note. Do we keep two distinct files? One is the medical record and the other is the psychotherapy note. That's what's being suggested in order to maintain the heightened privacy of the psychotherapy note. Russ Newman, in his role as the director of the practice directorate for APA, was among the folks who was recommending keeping two different records. And that does protect the psychotherapy note from some types of access. It's important, though, not to confuse the separation of these records with the idea that we can withhold the psychotherapy note in all circumstances. Two examples. The first one is that if a client gives an authorization for me to send a psychotherapy record, say, for example, to their lawyer, I can't withhold it simply because it's a separate record. I have to get their authorization to do so, but once I have it, I have to disclose it. Similarly, if I get a court order saying, give me, or even a subpoena that's valid and that the client says, I don't want you to fight, that says, give us all of your records relating to client X. I can't simply send the medical record and not the psychotherapy note, again, so long as I've got an authorization from the client or I have a court order. But having said that, given those two exceptions, the idea of keeping two separate records has been one that's been floated and that at least some agencies and some practitioners are using. The literature that I have read on this distinction between the psychotherapy note and the medical record has tended to talk about the psychotherapy note as a process note. There was one law review article that said that's all it is. However, that's not what other authors are saying, and that's not what NASW and APA are saying. So I tend to think of it as the more content-related information, and it could be something as extensive as a process note, but not necessarily a process note. Just like the psychotherapy note, if we were to keep a process note, patients would not necessarily have access to that. We get to decide, but if there's a court order, the court's going to have access to it. So we have to be very careful with process notes, as I'm sure most of you are aware. I have been in clinics where the printer, which printed therapy notes, although upside down, that is facing down, was stored in the hallway where clinicians and adult and child clients could walk to the clinician's office. I raised a concern about this, but nothing was ever changed. What were your thoughts about this issue? That's really a problem. You know, I understand that, you know, particularly if you have many different clinicians using the same printer, that it is more efficient to have a whole bunch of people use the same printer, but we have to be mindful of privacy. Now that situation, it's interesting that you raised that question. We have a similar problem here with records that are FERPA protected. So if I print out in our common printer records of a student's educational performance, that's protected and confidential and actually should not be printed out in the public domain, just here at school. So one of the ways we deal with that here, because we do have common printers, is we will queue something up for printing and then walk out and collect it and not allow anybody else to get it. But we do have to be careful about allowing access to records in this kind of incidental way. This is the kind of thing that people have been talking about vis-a-vis, to go back a little bit to HIPAA, but still to stay on record issues, vis-a-vis having computer screens available to be viewed by people who are clients or patients. So they walk into an office, and I've got my computer screen up, and I've got my records about a different client. That's clearly a privacy compromise. And just like printing treatment notes or identifiable patient information in a hallway, having for a person to view who does not have legitimate both ethical and legal access to that information is not okay. It's a violation of confidentiality. And so I would be trying to think within a clinic, if that's happening, or an agency, you know, administrators, we struggle with how to make things work